A pleasant day, everyone. My name is Guadalquiver, and for today's video, we will be going to tackle about the legal aspects in tourism and hospitality, Chapter 3, with the title of Law on Obligations and Contract. So we have here the learning objectives. Number 1, identify the different kinds of obligations and contracts. Number 2, enumerate the ways of extinguishing an obligation. Number 3, enumerate possible applications of contracts in tourism, travel, and hospitality industry. Studying fundamental principles of law on obligations and contracts is crucial for those operating in the tourism, travel, and hospitality industry to avoid potential breaches. Article 1156, an obligation is a juridical necessity to give, to do, or not to do. Article 1156 of the Civil Code of the Philippines establishes the concept of obligation as a juridical necessity. This legal term refers to the compelling duty to either give, perform an action, or refrain from an action. For instance, a specific example could be a contract where one party is obliged to deliver a certain quantity of goods, or obligation to give or perform a service, or obligation to do or abstain from competing with the other party for a specified period. The article forms the basis for understanding legal responsibilities in various contexts, such as contracts and civil relationships. Obligations of passive subject. Obligations to give a determinate thing. Number 1, to deliver the thing which he has obligated himself to give. For example, in a sales contract, if Party A agrees to sell a specific piece of artwork to Party B, Party A is obligated to deliver that exact artwork to Party B. Number 2, to take care of the things with the proper diligence of a good father of a family. For instance, if someone borrows their friend's car, they are obliged to take care of it as if it was their own, using the standard of care expected of a responsible car owner. Number 3, to deliver all its accessories and accessions. For instance, in a real estate transaction, if a person sells a house, they are obligated to deliver not only the main structure but also any attached structures or accessories and any improvements made to the property or accessions. Number 4, to pay damages in case of breach of obligation. For instance, if a contractor fails to complete a construction project within the agreed upon time frame, they may be obligated to pay damages to the client for the losses incurred due to the delay. Letter B, obligations to do. If the debtor fails to do what he is obliged to do, it will be done at his expense. For example, if a musician is contracted to perform at an event and fails to show up, they may be obligated to cover the cost of hiring a replacement musician to fulfill the performance. Number 2, if the artwork is done in contravention of the tenor of the obligation, it will be redone at debtor's expense. For example, if a painter is hired to paint a house in a specific color scheme but deviates from the agreed upon colors, they may be obligated to redo the entire painting job at their own expense to meet the terms of the contract. Number 3, if the work is poorly done, it will be redone at debtor's expense. For example, if a software developer is contracted to create a custom software solution and delivers a product with numerous bugs and errors, they may be obligated to rectify the issues and improve the quality of the software of their own expense. Article 1157, obligations arise from number 1, law. Obligations can arise from laws enacted by legislative bodies. These obligations are binding on individuals or entities by virtue of legal statutes. Number 2, contracts. Obligation can stem from agreements between parties. When individuals or entities enter into a contractual relationship, they voluntarily assume certain duties and responsibilities when become legally enforceable. Number 3, quasi-contracts. Quasi-contracts are legal constructs that create obligations similar to those arising from contracts. Even in the absence of a formal agreement, these obligations are imposed by law to prevent unjust enrichment or to ensure fairness in transactions. Number 4, acts or omissions punishable by law. Obligations can also arise from actions or failures to act that are punishable by law. Individuals or entities may be obligated to compensate for damages or injuries resulting from their unlawful conduct. Number 5, quasi-delicts. Quasi-delicts, also known as torts or civil wrongs, refer to wrongful acts or omissions that cause harm or injury to another party. Obligations arising from quasi-delicts involve the duty to compensate for the damage inflicted, even the absence of a contractual relationship between the parties involved. Classifications of obligations. Primary classifications of obligations under the Civil Code, Articles 117 to 1192, or pure and conditional obligations. Pure obligations are straightforward commitments without any conditions, while conditional obligations, on the other hand, depend on a specific event or circumstances to occur for their fulfillment. For instance of pure obligation, a promise to deliver a certain item on a specific date. And for example, for the conditional obligation, a promise to pay a debt only if a certain business deal is successful. Number 2, obligations with a period, or Articles 1193 to 1198. These obligations have a specified time frame or period within which they must be fulfilled. For instance, a lease agreement for an apartment for a period of 1 year. The obligation to pay rent and occupy the premises lasts for the specified 1 year period. Number 3, alternate and facultative obligations, or Articles 1199 to 1205 and 1206. Alternative obligations give the debtor a choice between different ways of fulfilling the obligation. Facultative obligations provide an initial method of fulfillment but allow the debtor to choose a substitute performance under certain conditions. So for instance of alternative obligation, a contract allowing the delivery of either a specific car or a specified amount of money. And for example, for the facultative obligation, a promise to deliver a certain product, but the debtor can provide an equivalent substitute of the agreed upon item is unavailable. Number 4, joint and solidary obligations, or Articles 1207 to 1222. Joint obligations involve multiple debtors, each responsible for a share, while solidary obligation make each debtor individually responsible for the entire obligation. So, for example of joint obligation, two friends borrowing money together, each responsible for half of the debt. So, for example, on the other hand of solidary obligation, a business partnership where each partner is individually responsible for the entire debt of the business. Number 5, divisible and indivisible obligations, or Articles 1223 to 1225. Divisible obligations can be fulfilled partially or on installments, while invisible obligations must be fulfilled as a whole. So, for example of divisible obligation, a contract for the monthly supply of goods allowing for separate payments and deliveries. And on the other hand, invisible obligation, a contract to construct an entire building with payment due only upon completion of the entire project. Number 6. Obligations with a penal clause, or Articles 1226 to 1230. These obligations include a penalty or consequence for failure to fulfill the primary obligations. So, for example, a contract for timely delivery of goods with a penalty clause stating that a specified amount will be charged for each day of delay in delivery. Secondary classifications of obligation under the Civil Code. So number 1, unilateral and bilateral obligations, or Article 1169 to 1191. Unilateral obligations involve only one party being bound to perform an action or provide something, while bilateral obligations, also known as contracts, involve mutual promises between two or more parties. So, for example of unilateral obligation, a reward promised or for finding a lost item. And for example of bilateral obligation, a sales contract where one party agrees to sell a product and the other agrees to buy it. Number 2, real and personal obligations, or Articles 1163 to 1168. Real obligations are those that involve specific properties or assets, while personal obligations are based on the person's obligation to perform a certain action. So, for example of real obligation, a mortgage where the debtor pledges a property as security for a loan, while personal obligation is like a promise to pay a debt not tied to any specific property. Number 3, civil and natural obligations, or Article 1423. Civil obligations are legally enforceable, arising from contracts or laws, while natural obligations are moral or ethical duties that are not legally enforceable but may be fulfilled voluntarily. So, for instance, civil obligation, payment for services rendered under a contract. So, while the natural obligation is a repayment of a debt that has expired under the statute of limitations, where the debtor has a moral obligation to pay but is not legally required to do so. Number 4, legal, conventional, and penal obligations, or Articles 1157, 1159, and 1161. Legal obligations arise from laws or statutes. Conventional obligations arise from agreements or contracts between parties, and penal obligations involved obligations imposed as a punishment for wrongdoing. So, for example of legal obligation, paying taxes as required by tax laws. Conventional obligations, fulfilling the terms of a lease agreement between a landlord and a tenant, while penal obligation is paying fines imposed by a court for violating traffic laws. Modes of extinguishing obligations. Article 1231, obligations are extinguished. Number 1, payment or performance. The obligation is discharged by fulfilling what was agreed upon, either through payment of money, delivery of goods, or completions of service. So, for instance, if you borrow money from a friend and then repay the entire loan amount as agreed, the obligation is extinguished through payment. Number 2, loss of the thing due. So, if the subject matter of the obligation is lost or destroyed, the obligation is considered fulfilled because the intended item is no longer available. So, for instance, if someone is obligated to deliver a specific piece of artwork but it gets destroyed in a fire before the delivery, the obligation is extinguished due to the loss of the artwork. Number 3, condonation or remission of the debt. So, the creditor forgives or releases the debtor from the obligation, leading to its extinguishment. So, for instance, a lender forgiving a portion of a borrower's debt and considering it fully paid, thus extinguishing the obligation. Number 4, confusion or merger of rights. So, when the rights of the creditor and debtor are combined in the same person, typically through inheritance or a change in legal status, the obligation is extinguished. So, for example, if a debtor inherits the rights as a creditor, the obligation may be extinguished due to the confusion of roles in the same individual. Number 5, compensation. So, debts between two parties are set off against each other, and the smaller obligation is extinguished by the large one. So, for instance, if A owes a if A owes B a $500 and B owes A $300, the two debts can be compensated with A paying only the net amount of $200. Number 6, novation. The substitution of a new obligation for an existing one with the consent of all parties involved. So, for instance, if a person owes a debt to a bank and the bank agrees to accept a different asset, such as a car, as payment instead of the original cash obligation, novation occurs, extinguishing the initial debt obligation. Contract. Article 1305, a contract is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some service. So, a contract is formed when two individuals agree on certain terms, and one commits to providing something or performing a service for the other. The essential elements of a contract are as follows. First, the consent, which is manifested by the meeting of the minds of the offer and the acceptance upon the thing and the cause which are to constitute the contract. The offer must be certain and the acceptance absolute. B. Object certain, which is the subject matter of the contract, and C. Cause of the obligation, which is established. Characteristics of contract. Number 1. Mutuality of contracts. For a contract to be valid, both parties must freely and willingly agree to the terms. There must be a mutual understanding and consent between the parties involved. So, for example, if person A offers to sell a laptop to person B and person B willingly to accept the offer, there is mutuality in the contract. Number 2. Autonomy of contracts. Parties have the freedom to determine the terms and conditions of their contract as long as it is within the bounds of the law. The law respects the autonomy of individuals in entering into agreements. So, for instance, two businesses negotiating and agreeing in the term of a partnership contract, determining the rights and responsibilities of each party within legal limits. Number 3. Relativity of contracts. Contracts create rights and obligation only for the parties involved. They do not affect individuals who are not part of the contract. So, for instance, if person A and person B enter into a lease agreement for an apartment, the term and obligations in the contract are applicable only to A and B, not to other unrelated individuals. So, number 4. Consensuality of contracts. Contracts are formed based on the meeting of minds or mutual agreement between the parties. It emphasizes that the essence of contract lies in the consent of the parties. So, for instance, two friends agreeing to exchange their books for a specific period, the consensual agreement creates a valid contract. Number 5 and the last, obligatory force of contracts. Contracts create legal obligations, and once formed, parties are bound to fulfill their agreed upon promises. Failure to do so may lead to legal consequences. So, for example, if person A agrees to provide a service to person B for a fee, both parties are obligated to fulfill their respective roles as per the contract. Non-compliance may result in legal action. And that's all of my report. I hope I deliver the topic clearly. And thank you for watching and listening. Have a nice day ahead.